So picture this. Two people meet, maybe through, let's say, a lurid correspondence from some marriage publication back in the day. Big promises get made before the wedding. We're talking property, wills, maybe even involving, seven figures. How does the law actually handle those promises? Especially when nothing's written down. That precise situation is what we're diving into today, our mission, to really get under the hood of one of the oldest legal ideas in contracts, the statute of frauds. We're focusing tightly on the specific bit about agreements made upon consideration of marriage. And we're going to use a pretty notorious case from 1913, Dienst v. Dienst, to model that rigorous, step-by-step legal analysis needed to figure out if a promise holds up or just vanishes.
Yeah, and that element-by-element breakdown, it's absolutely vital here. Because this part of the law, well, it's incredibly strict. Unforgiving, really. So we'll start with the basic rule, the black-letter law. What makes one of these pre-wedding agreements fall under the statute of frauds in the first place? Then we'll dig into the dramatic facts of the Dienst case, do a really precise walkthrough of how the court analyzed it, and we'll wrap up with a kind of diagnostic checklist, step by step, giving you the tools to spot this issue and structure your own analysis when you see these kinds of promises.
Okay, let's get into it. To start us off, what's the fundamental legal hurdle here? What stops certain verbal agreements from being enforced, especially when marriage is part of the picture?
Right, so that hurdle is the statute of frauds. It's an old legal concept, basically saying that certain important types of contracts have to be in writing to be enforceable, to prevent fraud and misunderstandings. The specific rule we're looking at today says that any agreement, promise, or undertaking that is made upon consideration of marriage, and this is key, except for the simple mutual promises to marry, is void. Completely void unless there's some kind of written agreement or note signed by the person making the promise. The absolute core idea is the consideration. The statute kicks in and demands that writing, whenever the act of getting married itself is the price paid, or the main reason, or the condition that triggers the promise about property or money.
Okay, that sounds quite specific, but Dienst v. Dienst really shows how broad that can be in practice. Let's dive into that case. First off, what are the key facts? What actually happened between Mr. and Mrs. Dienst?
Well, the facts certainly paint a picture. You had the complainant, the wife, who was 62 and quite wealthy, in a estate worth maybe $60,000 or $70,000 back then, which was a lot. Then you have the defendant, the husband, 66 years old, and, as the court bluntly put it, penniless. They met through one of those marriage brokerage publications. The husband's claim was this. He said they had a verbal antenuptial agreement. Before the marriage, she promised him she'd make a will, leaving her entire estate to him if he outlived her. Later, things went sour, she filed for divorce, and he filed a cross bill trying to enforce that verbal promise about the will.
All right. And given those facts, what was the central legal issue the court had to decide regarding the husband's claim?
The precise legal question boiled down to this. Was that verbal agreement the husband claimed, the promise about getting the wife's estate, was it legally made upon consideration of marriage? If yes, then because it wasn't written down, it would be totally void and unenforceable under the statute of frauds.
Makes sense. So what rule of law did the court use to answer that question? Can you lay out the principle and its essential parts, its elements?
Sure. The court applied that statute of frauds provision we just talked about, the one needing a writing for agreements upon consideration of marriage. And for analyzing the husband's claim in Dienst, the court essentially broke it down into two key elements they needed to test. First, was there actually an agreement or promise about property? Did that promise exist? And second, crucially, was that agreement induced by the marriage promise, or was it conditional upon the marriage actually happening?
Thank you. That sets up the framework perfectly. Now let's get into the court's elemental analysis. We'll take it step by step. How did the court deal with the first element, the existence of an agreement promise?
Okay, so for that first part, remember this was at an early stage, a demurrer. The wife was basically saying, look, even if everything my husband says is true about this promise, the law still says it's void because it wasn't written. So at that point, the court had to temporarily accept the husband's version of the story. He clearly alleged in his cross bill that she promised to make the will leaving him everything. So for the purpose of deciding the demurrer, the court said, okay, element one is met. We'll assume the promise existed.
Understood. Simple enough for that stage. But now we get to the really critical part, the controversy. What about the second element, the big one? Made upon consideration of marriage. The husband fought this hard, right? He argued the deal wasn't just about getting married. He said he gave things up, his home, his job, potential political opportunities, his whole life in Kansas. How did the court address that argument?
Yes, this is where the court really drew a sharp line. They essentially dismissed all those other things the husband claimed he gave up the job. Moving, the political stuff. The court basically said, those might have happened, but they aren't the legal consideration that matters here. To figure out the legal consideration, the court zeroed in on the direct link between the property promise and the marriage itself. And, crucially, they pointed to the husband's own legal filings. He himself stated the promise was made as a further consideration for the consummation of such engagement of marriage. And he said he relied on that promise when he immediately proposed marriage. So the court reasoned, if that property promise is what gets you over the line, what induces you to actually go through with the marriage, then legally speaking, it is upon consideration of marriage. Even if other sacrifices were made along the way. The fact that this proposal immediately followed the promise, that sealed it for the court. Element 2 was met.
Wow. So the court essentially said his reason for marrying her, which seemed to be getting the property, outweighed any actual financial or life sacrifices he made. That feels, well, incredibly harsh. He did rearrange his whole life based on her word.
It does feel harsh from his perspective, absolutely. But that harshness points directly to the policy behind the statute of frauds in this context. The law is really trying hard to prevent fraudulent claims about verbal promises, especially when large estates are involved after someone dies or a relationship breaks down. Because the husband's own claim framed the promise as an inducement for consummating the marriage, the law essentially presumes it falls under the statute. The other losses, while real to him, didn't break that fundamental link in the court's eyes. The marriage itself was the condition.
Okay, so the court methodically checked off both elements. Yes, there was a promise alleged, and yes, it was legally considered to be upon consideration of marriage. What was the court's final conclusion then?
The final holding was clear-cut. The court concluded that the agreement the husband described was undeniably made upon consideration of marriage. And because the statute of frauds absolutely requires such agreements to be in writing, and this one was only verbal, it was simply void and not enforceable, period. So the court upheld the lower court's decision, sustained the demurrer, and dismissed the husband's cross bill. The formality of the writing requirement trumped the verbal promise, no matter how life-altering it might have seemed.
That really hammers home the policy. The law demands that formality, that writing, to ensure clarity and prevent disputes over these very significant premarital agreements. Let's try a hypothetical to really cement this definition of upon consideration of marriage and how that condition works.
Good idea. Hypotheticals can make these distinctions much clearer.
Okay, imagine two scenarios. Scenario 1. The wife promises the husband, look, I will pay off your house completely if you marry me. Now, contrast that with scenario 2. She says, okay, 1 year after we get married, assuming we're still together and we actually move to Kalamazoo like we talked about, then I'll pay off your house. How does the statute of frauds, especially after Dienst, treat these two promises differently?
Great examples. The difference lies entirely in what triggers the promise. In your first scenario, I'll pay off your house if you marry me. The condition precedent, the thing that makes the promise kick in, is the act of marrying itself. That's the very definition of upon consideration of marriage, according to Dienst. Marriage is the price for the house payoff. So the statute of frauds applies directly, needs to be in writing if it's just verbal, void, just like Mr. Dienst's claim. Now the second scenario, 1 year after we marry and we move to Kalamazoo, is different. The promise to pay off the house isn't triggered solely by the act of getting married. It's triggered by things that happen after the marriage, surviving a year and performing another act, moving. The marriage itself isn't the direct consideration for the payment in that second case. It's more like a prerequisite status before the real conditions, time, moving, come into play. So the statute of frauds marriage clause likely wouldn't apply to that second promise, meaning a verbal agreement might actually be enforceable, assuming other contract rules are met.
Okay, so the critical lesson from Dienst, crystallized in that hypothetical, is if you can draw a direct causal line from the promise of money or property straight to the decision to actually get married, you absolutely must have it in writing.
Exactly. The courts, following Dienst, generally won't buy arguments about other sacrifices, like moving or quitting jobs, if the core inducement, the thing that sealed the deal for the marriage itself, was that property promise.
All right. So pulling this all together, let's say someone, maybe a student preparing for exams, or just anyone trying to understand a situation, is faced with a verbal promise about property made before a wedding. What's the step-by-step diagnostic checklist they should run through to spot this issue and analyze it properly based on what we've discussed?
Okay, definitely. We can boil down the Dienst analysis and the statute of frauds rule into a practical 4-step framework for issue spotting and analysis. Step 1, identify the promise. Just fundamentally, was there an agreement or promise made between two people who either later got married or were planning to marry? And did that promise involve property, or maybe an inheritance through a will or some kind of financial arrangement? Step 2. Locate the consideration. What was the reason given for that promise? What was the price, the inducement? You need to list out everything claimed marriage itself, moving, giving up a career, emotional support, whatever is alleged. Step 3. This is the crucial one. Test the link to marriage. Ask, is fulfilling that promise conditional upon the marriage actually happening, or was the promise made in exchange for the agreement to marry? Use that Dienst test. Did the promise directly induce the consummation of the engagement? If the answer seems to be yes, then ding, 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 the statute of frauds marriage clause is triggered. And finally, step 4, check for the writing. If you've determined in step 3 that the promise was indeed made upon consideration of marriage, the next immediate question is there a written document? Is there a note or memorandum outlining this agreement? And crucially, is it signed by the person who is now trying to get out of the promise, the party to be charged? If there's no sufficient signed writing, the analysis basically stops. Under the statute of frauds, that verbal promise is void. End of story, legally speaking.
That's a really clear, actionable framework. It really highlights the main takeaway from Dienst. If you're dealing with one of these prenuptial promises, trying to argue there was some other consideration besides the marriage itself is an uphill battle, almost impossible, if getting married was clearly tied up in the deal. The court's going to likely stick to the strict letter of the law to protect against potential fraud. Which leads to a final thought, something for you, our listener, to maybe wrestle with. Remember how the Dienst court used the husband's own words from his legal claim against him, showing his intent was tied to the marriage? When the law strikes down a promise that maybe both parties genuinely understood and intended, just because it lacked the formality of a signature on paper, is that truly justice being served? Or is it just the sometimes harsh but maybe necessary efficiency of black-letter law doing its job to prevent a different kind of injustice down the line? Something to think about.